Hello and welcome to our video. My name is John Watts. I'm a consumer protection lawyer in Alabama. And what you're about to watch is a video that really covers all the questions we've ever been asked about being sued in Alabama by a debt collector or a debt buyer. So these are companies like Midland Funding, LVNV Funding, Portfolio Recovery, Calvary, Cash, whatever it may be. And so what we've designed this for is to be as comprehensive as possible. Now, you may want to start at the beginning and watch all the way through. Or you may want to look in the description below, and you should see that we have timestamps for each question or each category. And we do walk you through from who are these people that are suing to what's the lawsuit, how do you answer, what happens before trial, during trial, after trial. We break it out between small claims, district, circuit court. So we try to make this as comprehensive as possible, and we hope that you find it useful. If you have any questions at all, either you've been sued, you're being threatened with being sued, or maybe you've already completed your collection lawsuit, now you're wondering what to do, give us a call, 205-879-2447, or you can go to alabamaconsumer.com. And we appreciate you watching this video. Hope that you enjoy it and it is useful for you. Take care. Bye-bye. Let me just describe some of the dangers that you face right now. You've been sued. A huge percentage of people allow a default judgment to happen against them. Now, whatever type of judgment, default judgment, or if you lose the case, then you face the danger of wage garnishment. That can be 25% of your wages. Or bank garnishment, where your entire bank account is wiped out. Having a judgment can destroy your credit report. And you can even lose your car or your home to what's called a sheriff's sale. And on top of all that, there's all this fake information out there about what debt collectors can do, what they cannot do, what your options are. And so that's why I'm making this video. And this will be a very long video. So if you're not interested in a long video, then I would stop watching it now. But we need to go through a ton of questions, provide very practical answers so that you can decide what to do. And really, this is the purpose of the video. We want you to know what your options are, and we want to encourage you to take massive action right now. Because if you just know what to do, well, that's not enough. And if you just take action without knowing what to do, you're not going to get a good result. You need knowledge plus action. Okay, so who in the world is John Watts, and why should you be listening to me? Why should you take your time with this? And I'll tell you this. I've been a lawyer since 1995, and for about the first 11 years or so, I knew nothing about collection lawsuits, about debt buyers, the Midland Fundings of the world, Portfolio Recoveries of the world. I just had no dealings with those guys. I did almost exclusively personal injury and fraud cases, and this was just foreign to me. But in the last about 11 years, I've represented hundreds of consumers who have been sued by debt buyers. I've lost track of how many consumers handle their cases on their own, and that is a real option for a lot of people. I've trained lawyers in Alabama, lawyers in other states about this, and you can go to alabamaconsumer.com, you can go to our YouTube channel, you can find just tons of information about this. So I hope that gives you some comfort to know that maybe at least in some small way I know what I'm talking about, and it'll be worth your time to listen to this video. So let me give you this disclaimer. I'm a lawyer, so I got to give you the disclaimer. I think you know all this, but let me just go through this quickly. I'm not your lawyer unless you hire me. I'm not giving you legal advice. This is background information. And look, everything we talk about, there will be exceptions, and even exceptions to the exceptions. I'm not covering those. I'm covering the high points here. And certainly, there are lawyers, particularly collection lawyers, and even judges that may disagree with what I say. And you have to make your own decisions about what to do. The purpose of this is to get you started and help you think through your situation so you can evaluate your 5 options. We'll cover those in detail. What do you do next? And this is only for Alabama. I don't know how other lawsuits work in other states. This is for Alabama. If you're in another state, get with a lawyer in your state to find out. And that's really the best advice I can give you is get with a lawyer in your state who knows what he or she is doing, and then they can give you specific legal advice for your situation. And to the extent this is considered advertisement, here's a disclaimer required by Alabama. No representation is made that the quality of legal services performed is greater than the quality of legal services performed by other lawyers. Okay, so how is this video organized? We're going to start off with lawsuits in general and a lot of background questions about what are these debt buyers or these debt collectors. Then we'll talk about being served, and then we'll talk about your 5 options, and then we'll focus on, okay, how do you get an answer filed in your case? And then what happens before a trial? What happens during a trial, both in general terms, but also in the 3 types of courts that we have: small claims, district, and circuit. And then what happens after a trial in each type of court. And then we'll close with what I hope is a very practical thing, and that is, okay, you've gone through all this video, all this information. What do you do right now? So let's get started, and I appreciate you joining me on this journey. Our first section is going to be, what is this lawsuit filed against me? Okay, well, let's go to our first section. What is the lawsuit filed against me? And let's start off with this question. What does being sued actually mean? Well, it means that somebody has gone into court and has filed a lawsuit or a complaint against you saying that you violated some law, you broke a contract, you did something, and now you owe them money. So in a nutshell, that's what being sued means in Alabama. Now, here are some kind of background questions because these often come up in people's minds. And so the first one is, I thought it was illegal to buy a debt in Alabama. Is that true? And the answer is no. At least not. It's not 100% true that nobody can ever buy a debt. Now, there may be some situations where it would not be legal to buy a debt. But when we're talking about credit card debt, car loan debt, student loan debt, mortgage debt, all that type of stuff, yes, that is legal to purchase in Alabama. So it is okay, it is proper for that to be bought in Alabama, assuming all the rules are followed. And the reason that I want to make a point about this is that there are a lot of people, very well-meaning people, that will put stuff out on the internet that says, oh, it's illegal to buy a debt anywhere in America. And so if somebody sues you and they claim to have bought a debt, you just ignore it because they can do nothing to you. That's just terrible advice. And so I want you to know that it is possible for a debt collector, or what's known as a debt buyer, to actually buy debt in Alabama. Now the next question, is it even legal for a debt collector to sue me in Alabama? Okay, so maybe they can buy the debt, but somebody will say, I heard it was not legal to sue me. Well, the answer is, assuming all the rules are followed, it is legal, it is proper for a debt collector to sue you in Alabama. Again, assuming they follow all the rules. They follow the federal rules, they follow Alabama court rules, Alabama law. There's a lot of places where these debt collectors or debt buyers violate the law. But it is possible that they can sue you in Alabama and do so legally. Now, a related question is, I can't be sued on a charged off debt, can I? And here's where this comes from. You look at your credit report and you see that maybe it's a Bank of America or a Capital One or a Chase Bank or whatever it is. It's a charged off debt. You say, well, hey, it's charged off. It's written off, so I don't owe it. Well, really, charge off is an accounting function, and it doesn't really have anything to do with whether or not you owe the debt. And so the answer to this question is, yes, you can be sued on a charged off debt. And let me just be more blunt. Basically, every single debt collection lawsuit is on charged off debt in Alabama. And so, yes, you can be sued on this. Well, final sort of background question. Isn't it true that judges will not allow these suits because debt collectors so often violate the law? Well, let's take that in a couple steps. The first part is absolutely these debt collectors violate the law very often. But judges are not going to just ban or prohibit debt collectors from filing suits or getting judgments against you just because in other situations they have violated the law. In other words, what a judge is concerned about is, let's take a very common debt buyer, Midland Funding. So we've got Midland Funding in the court and we have you in the court. The judge is not going to be looking at, well, I wonder what happened in other cases with Midland Funding, or do other debt buyers violate the law? The answer is yes, they do. Yes, Midland Funding violates the law. But the question is, in your particular trial, the judge is only going to be concerned about what does the law say, what is the evidence in your case, not in some other case. So to answer this question, no, it is not true that judges will somehow ban or prohibit these lawsuits because we're dealing with a bunch of abusive debt collectors. We are dealing with abusive debt collectors, but they have the right to sue you as long as they follow the law. Okay, so now let's get into the actual lawsuit. So what is the, quote, complaint, end quote, or the statement of claim? Well, that's simply the document that starts the lawsuit. It'll have your name on it. It'll have the debt collector, the debt buyer's name on there. And hopefully we'll have some information about what is this about, what's the underlying debt, how much do they claim you owe. Now, a lot of times these have very little information. Sometimes they have quite a bit of information. But this is the starting point that begins the lawsuit. All right, here's a very common question when people know that they've been sued or they've been served, and we'll talk about that later. But what is the statute of limitations on collection lawsuits? Well, this is a somewhat controversial subject in Alabama when we're dealing with debt collection lawsuits. Let me give you kind of the broad picture. Clearly, there are some types of cases where it is a 3-year statute of limitation. Then there are some types where it is a 6-year statute of limitation. And then some, it's a 4-year statute of limitation. So let me give you a little more detail. Those of us on the consumer side argue that credit card type lawsuits are 3-year statute of limitation. Now the collection lawyers say, oh, no, it's 6 years. Frankly, some judges go one way and some go the other. There's not absolute clear authority from the Alabama Supreme Court. At least that's being generous to the debt collectors. I do believe it is 3 years, but we have to acknowledge there's a chance that a judge could say it is 6 years. Now, if we're dealing with an old car loan, then we have to get into a little bit of detail. Did you go get that money from a bank? So here's one way you get a car loan. You go to the bank, you go to the credit union, they say, all right, you're approved at $20,000. You go down to the dealership, you buy the car, the bank pays the car, and then you pay the bank. Well, that is most likely 6 years. But what if you go to a dealership, you agree on $20,000, dealership says, I'll get you the credit. And then when you look at the sales agreement, it says the dealer is the seller and the creditor. Now, they may very quickly assign that to City Auto or Capital One Auto or somebody like that, and then it may get assigned or sold down the road to companies like Santander, Cascade Capital, Velocity. Now, at least those companies claim that they buy it. Now, that we're normally looking at a 4-year statute of limitations. So bottom line is, this is not always the easiest thing to figure out. And my suggestion is get with a lawyer. Presumably if you're watching this, you live in Alabama, just get with us and we'll help you figure out in your particular case, what is statute of limitations. And related to statute of limitations, that is a type of defense, here's the question. Do I really have a chance to beat this lawsuit? And the answer is yes. Maybe the statute of limitations has expired, which means it's too late for the debt collector to sue you. But even more than that, we have beat, I can't tell you how many of these debt buyers and just hundreds and hundreds of lawsuits because they cannot prove they own the debt. So you absolutely have a chance to beat these guys in the lawsuit. And that's why it's such a shame when people just do nothing and they let a default judgment be entered against them when they could have beat this debt buyer or debt collector. All right, so let's talk about this. Who is a debt buyer? Who is this company suing me? I've never heard of them. Well, that's most likely true that you have been sued by maybe it's Calvary or LVNV, Midland Funding, Portfolio Recovery, Velocity. I mean, there's just dozens and dozens of these companies. And you're saying, wait a minute, I never borrowed any money from Midland Funding. Why are they suing me? Well, because they claim, very important that we focus on that word, they claim, they allege that they have bought the debt. Now, if that's true, then they are a, quote, debt buyer because they have bought this old debt. And then when they buy the debt, then they sue you. So that's the theory of this industry anyway. All right, here's a question. Can I go to jail because of this debt collection lawsuit? The answer is no. We don't send people to jail because we owe money. If you lose the lawsuit, then you will owe money. And there are things that can happen if you owe money, but going to jail is not the natural consequence of, okay, I lost a debt collection lawsuit. So what is a judgment? Well, a judgment is when the court issues an order and it decides or it judges between the two parties. So say it's Portfolio Recovery and you. If there is a judgment, it says who won and who lost. So the judgment is just the final ruling by the court. And if the consumer loses, then that's how much you owe this debt buyer. If the debt buyer loses, then you do not owe the debt buyer any money. All right, what is a default judgment? Well, it's kind of like the word says, if we default, we don't show up. We don't put up a fight. We just lose. So imagine the Iron Bowl in Alabama. And whoever your team is, and you're confident your team's going to win, and they do not show up to the game. Well, what happens? Well, your hated enemy team wins the game because your team defaulted. So a default judgment in a lawsuit context is maybe we do not respond to the lawsuit, and so we have defaulted. There are certain time limits involved. Or maybe we have responded, but we don't show up to trial. And then the court can say you have defaulted. So that's what a default judgment is. All right, if there's a judgment, can my wages be garnished? Absolutely. That is sort of the classic way these debt collectors have to collect on that judgment, or sometimes what's called execute on that judgment, is to garnish your wages. So then the question becomes, well, how much can my wages be garnished if I lose the lawsuit? Well, the basic rule is 25%. Now, again, there are exceptions and things we're not getting into that, but just you think about that, and here's kind of a quick and dirty way to think about it. 25% of your take-home pay. So whatever your paycheck is every week, every 2 weeks, once a month, divide that in 4, and you lose 1/4 of that. So if your wages are $4,000 a month, your paycheck, well, you'd lose $1,000. If you get, $1,000 every 2 weeks, well, you may lose $500 a week to wage garnishment. So obviously very devastating for us. How about your bank account? Can your bank account be garnished? Absolutely. Now, there are some exemptions if we have Social Security type money in there. But just understand, if you get a judgment against you, and I don't care if it's a default judgment or a judgment after a trial, your bank account is at risk of being garnished. Well, how much can they take from my bank account in a garnishment? Here's the thing. They can really take all of it. So So imagine that. You've got money in your bank account and it all gets wiped out. So what do? What about checks you've written? Well, those checks are going to be bouncing. What about checks you need to write? What about money you need from that account to live on? It's gone. It's been garnished. So let's think about this. Since I got sued, does that mean the debt collector owns the debt? And I'll tell you, this is a question that a lot of people get wrong. And by getting this wrong, they end up doing nothing because they assume, well, Portfolio sued me, LVNV sued me, Midland Funding sued me, so therefore the debt collector must own the debt. No. Do not assume that. That is what the debt collector is alleging, what they're claiming. But now they have to prove it. It's one thing to claim something. So here we go. I'm recording this in 2017. I am the President of the United States of America. I just made that claim. I just made that allegation. It might not be true. Okay? I may not be the President of the United States of America. So just because somebody says something does not mean it's true. Even in a lawsuit, they say, they claim, they allege, they own the debt. Do they? Well, they have to prove it unless you default. If you default, then as a practical matter, the judge will say, well, I guess it must be true. So let's talk about this. We have brought up this idea of does the debt collector own the debt? So what is the difference in owing and owning the debt? And this goes all the way back to a blog post we wrote, I think in 2006 or 7 about this. And it was an incredibly popular blog post because I think we were the first or one of the first to really recognize this distinction. So let me give it to you this way. The debt collector in a lawsuit, in a trial, is going to focus in on that you owe, let's say, Synchrony Bank. You know, they have a lot of the store cards and maybe the Walmart cards now. And so they're going to say, isn't it true that you took out a $3,000 credit card with Synchrony Bank and you spent that money? Yes. And you did not pay that back? Yes. And then the debt collector goes, Judge, I think I proved my case. And see, a lot of people go, well, yeah, I guess they did. They prove I owe the debt. But here's the thing. Do you owe that debt to Midland Funding, to LVNV, to Portfolio? That's the question. So let me give you an example. I owe money to my mortgage company. No question about it. So can you sue me for the money I owe my mortgage company? Yeah, I'm thinking not, unless you own that mortgage now. See, it's not enough to show I owe somebody money. The debt buyer must show I owe that company the money. And they show this by proving they own the debt. So absolutely critical to understand there's a absolute difference between owing a debt and the debt collector, debt buyer owning the debt. They can prove you owe the debt and still lose. As a matter of fact, that is true of virtually all the cases we've had. I mean, just hundreds and hundreds and hundreds of cases. You know, we owe the debt. It was not identity theft. So we owe the debt, but do we owe it to LVNV or Portfolio or Midland Funding? No, because they have to prove they own the debt. One last example. This is silly, but I think you'll get the point. Imagine I witnessed Bob Smith running a red light and crashing into somebody. Can I sue Bob Smith for the car wreck? Now, I can prove Bob Smith ran the red light. He was negligent. He was careless. He violated the safety rules. Okay? We do this all the time in our personal injury cases. But then Bob Smith would say, well, wait a minute, John. I did not hit you. I hit a woman. I go, yeah. Look, let's not focus on that. Let's focus on you ran the red light. You're guilty of running the red light. The judge would throw me out of court and say, well, John, it doesn't matter if he ran the red light. It does not matter if he hurt somebody. The person that got hurt has to come do the suing. Same thing in, for example, credit card context. They may can prove you owe Bank of America, Chase, Synchrony Bank, Capital One, but if this is a debt buyer that is suing you, they have to prove they own the debt. So always remember that very critical distinction. All right, and this is very similar, but if I owe the old credit card debt, does this mean I owe the debt buyer who sued me? No, unless the debt buyer can prove it owns the debt. Otherwise, it's just some stranger. Remember my example of I owe my mortgage company, but that does not mean I owe you. Or maybe I ran a red light. That doesn't mean you can sue me unless you were involved in the wreck. So just because you owe this old credit card debt does not mean you owe it to the debt buyer unless the debt buyer can prove it owns the debt. Now here's one that it surprised me first time I was asked this, but I've been asked a number of times, so I want to put it in here. Does the collection lawyer have to prove that he or she owns the debt they're suing me on? Well, the answer is no. The collection attorney does not have to prove that the lawyer owns the debt. What the lawyer has to do is prove that the plaintiff, the debt buyer, the debt collector who's suing you owns the debt. So keep in mind, if you're sued and you look at the lawyer's name and it says Moxley and Associates for Midland Funding, that is not Richard Moxley saying I own the debt. He's saying, look, I'm the lawyer for Midland Funding who allegedly owns the debt. Or if you see that the law firm is Nathan and Nathan, well, they're not saying that they own the debt. And for example, they're suing you for Capital One. They're not saying we bought the debt from Capital One. They're saying, hey, we represent Capital One. So the collection lawyer is merely representing the debt buyer or the debt collector. And so unless there's some unusual situation where the lawyer comes into court and says, yes, I bought this debt, it's very, very rare. So just keep this in mind. The collection lawyer has to prove the plaintiff, the company that sued you, owns the debt, not that the collection lawyer owns it. A lot of times we ask people to pull their credit reports and they say, well, why should I look at my credit reports? Why should I pull my credit reports when I'm sued by a debt collector? Well, the answer is that we want to know, what is the original creditor saying about dates of payment, last payment, because that can have a big impact on statute of limitation. We also want to know, what is the amount that the original creditor says? What is the amount that the debt collector says, the debt buyer? What are the dates they put on your credit report? A lot of times we can find contradictory information, which then is very useful if we're trying the case and portfolio recovery says X in the lawsuit, but then in your credit report they say the opposite of that. That's good for you and bad for them. You know, they've got some splaining to do when they have these contradictory things. So that's why it's important to look at your credit reports. Now, you can pull your credit reports for free through annualcreditreport.com. Annualcreditreport.com. And if you go there, you can see how to download them. You can also find a phone number. You can also mail in a little form to get them mailed to you. And if you have any problems or questions about that, just give us a call. But that's the way to do it for free. It's 100% free. You're not putting in your credit card. You're not signing up for a monitoring service. This is the legitimate way to get your actual credit reports for free. So that's what we have for years recommended. People go to annualcreditreport.com to pull their credit reports. Okay, well, kind of big picture, what happens after the lawsuit's filed? Well, the next thing is they will try and serve you with the lawsuit or hand you the lawsuit. So after you've been served, and we're going to cover this in detail, but after you get served, what happens? Well, Now the clock starts running for you to answer or respond to the lawsuit. All right, well, what about after you answer or respond to the lawsuit? What happens? Well, then normally you're going to trial after that. All right, so let's kind of break these down. What does it mean to get served? Well, being served simply means that under the definition of the law, you have been handed, and we'll talk about that in a second, but you've been handed the lawsuit papers, either directly or an adult who lives with you or by certified mail. But it means you now know about the lawsuit, you've been properly served, and now the clock starts running on how long you have to respond to that lawsuit. So here's a question about being served. Will a sheriff's deputy really serve me? Yes, they will. That's quite common for a sheriff's deputy to come up and say, hey, I've got some legal papers for you, some lawsuit papers. Here you go. Well, what about a non-law enforcement person? Can they serve me? Yes. This is what's known as often called a private process server. Could be a private investigator. Could just be somebody that this is all they do is serve lawsuits, or maybe they serve subpoenas. But yes, as long as they meet the requirements under the law, then they can serve you, and that is officially being served. Well, here's the next question. Can the process server really leave the lawsuit with an adult who lives with me, and that counts as being served? Yes. Now, it has to be an adult or a responsible person who, when I say responsible, I mean they have to be competent. Okay, so we're not talking about an 8-year-old child. We're not talking about somebody who has a mental disability, but a competent person who lives with you, not your next door neighbor who he's out cutting his grass and they hand it to your next door neighbor, or somebody that's visiting you for a few days, but they live with you. That's the key. And that can count as being served. Now again, there are all sorts of rules with that, but just big picture, that can count. How about certified mail? Can you be served by certified mail? Yes. So you get the little green card, or actually you get the, I'll talk about the green card in a second. So what about certified mail? How does that work with you being served? Well, you'll get a letter, and sometimes it's left in your your mailbox or whatever, but typically it's a little card if you're not there. And then you go to the post office, or the mail person brings it to you, and you sign for it, and then now you have officially received that envelope that has the lawsuit papers in it. So a lot of times we're asked this question: should I try to avoid the service? So if I see the sheriff's deputy, should I take off running? I had somebody call me one time, and they were hiding in their closet as the sheriff's deputy was knocking on their door, and they were asking me, I'm just going to not answer the door. Is that a good idea? And I'm like, no, don't. My suggestion is do not avoid the service. If somebody's trying to hand you the papers, don't jump in your car and race off down the road. Don't pretend you're not at home. Now, obviously, be safe. Some stranger at 10 o'clock at night's knocking on your door, you're not obligated to go open the door. So be safe, but I would not avoid the service. If they're trying to serve you, just accept it and then get on with what you need to do with this lawsuit. Otherwise, you're always going to be looking over your shoulder, wondering if they're about to serve you. They're going to take it to somebody that lives with you. They're going to show up at your job or your school, just embarrass you terribly. So I would not try to avoid the service. All right, well, once I'm served, what are the deadlines I have to meet? And we'll talk about this again, but here's the big picture. Once you're served, if you were sued in small claims court, you have 14 days to respond. If you were sued in district court, you also have 14 days. And if you were sued in circuit court, you have 30 days from when you were served. Well, what if I don't file my answer in time? Will the collector get a default judgment against me? The answer is almost 100% of the time, yes. Now, let me give you a little bit of background. So you've got 14 days from when you were served if you're in district or small claims, 30 days in circuit court. If you go beyond that time, some of these collection lawyers will, boom, they will nail you like the very next day with the default judgment. Some of them will give a little more time. okay, just to make sure that you haven't responded. But I suppose that there is a case somewhere where somebody failed to answer and there was no default judgment entered against them. I've not seen that. So I'm just going to say in 99.999% of the time, yes, if you do not answer in time, be expecting a default judgment, and usually immediately after you go past the deadline. All right, so you've been served, you're wondering what to do, maybe you're working with some debt settlement company, or you run across an out-of-state law firm that has nobody licensed in Alabama. Should you hire those guys to handle the lawsuit? Well, I'll tell you, this is almost always a complete disaster. Okay, so these debt settlement companies, a lot of these are scam companies. They'll say, hey, you stop paying everybody, you just pay us money and we'll make it all go away. And then when you get sued, they want you to continue to pay them money. It's like, oh, yeah, we'll take care of it. We'll work on it. We've got a lawyer that will handle this. And they don't, because they want to keep getting your payments. And then remember what happens if you do not answer in time, there's a default judgment against you. Now, an out-of-state law firm, well, what can they do? Nothing. They can't file an answer for you in Alabama unless they have a licensed Alabama lawyer. So if you hire a debt settlement company, if you hire a lawyer that's not licensed here, it's just a disaster. You have much better options than that. I mean, almost any other option would be better, because virtually everybody I see who uses a debt settlement company when they've been sued, or they use some law firm that has no Alabama lawyer, it ends up with a default judgment. And then these companies say, hey, good luck with that, but we can't help you. And then they won't answer your calls anymore. So again, you've wasted your money and you have a default judgment against you. All right, so let's talk about what your real options are, not using some bogus settlement company or some law firm that has no licensed Alabama lawyer. What are your options? Well, you have 5 of them. You can file bankruptcy, you can fight the lawsuit on your own, you can settle the lawsuit on your own, you can hire a lawyer to fight it or hire a lawyer to settle it. We'll just quickly go through these and then we'll cover them in more detail. So should I file bankruptcy? Well, bankruptcy is an extreme option. Very, very rare that it would be appropriate. Maybe you're that person that it would be appropriate for, but very, very rare that you should look at bankruptcy. I mean, you can take a look at it, but as far as actually deciding to do that, it would be very rare that, in my opinion, that's appropriate. How about fighting the lawsuit on your own with no lawyer? You know, a lot of times people will say, a lawyer represents himself as a fool for the client. The idea is you don't want to represent yourself. And there's a lot of wisdom to that. But sometimes in the right court, you can actually do this on your own, and this can be the best option. How about settling the lawsuit on your own? This can be a good option. Now, I think it's usually there are better options than this, but it may be that you want to settle this and you want to do this on your own. And that can certainly be a good option. How about hiring a lawyer to fight the case? Well, this can be a great choice, but you need to know where are you getting into, what's the cost, how's this going to work, and we'll talk about this in detail. How about hiring a lawyer to settle the case? Well, again, this can be a fine choice. You just need to make sure you understand all the costs involved. In other words, are you paying the debt collector any money? Well, how much will you pay him? How much are you paying the lawyer? What's the lawyer going to do for you? So just make sure that you know what you're getting into. Okay, now let's really dive into the first option of bankruptcy. So why do I say bankruptcy is such an extreme option? Well, when you file bankruptcy, that is going to be on your record. In other words, 25 years from now, if somebody says, have you ever filed bankruptcy? You've got to answer that honestly and say yes. What about your credit report? Well, it stays on your credit report for many, many years. And so you can kind of think of this almost as the nuclear option. I mean, this is when all else fails, there's no hope, no light at the end of the tunnel, and there's nothing else you can do. Then you look at bankruptcy. Well, why is it a life-altering event? Well, because it stays on your credit report for so long, and you always have to say, yes, I have filed bankruptcy. Now, when it's appropriate and it is extreme circumstances, this can be extremely effective. But you've got to go into it with your eyes wide open, knowing this is going to make a major change in my life. So what's the difference in a Chapter 7 and a Chapter 13 bankruptcy? A Chapter 7 is sometimes called a straight bankruptcy. It's where you're trying to wipe out your debt. Now, there's certain debts you cannot wipe out, but generally credit card and other stuff you can wipe out if you qualify. So the idea is you file the bankruptcy, and then a short period of time later, your debts are discharged or wiped out. Chapter 13 bankruptcy is often called debtor's court. And the idea with Chapter 13 bankruptcy is we're going to gather all of our debts together, and we're going to make payments over 3 or more commonly 5 years. And so we're making payments into court, and then the bankruptcy court distributes the money out to your various creditors. All right, if I want to file bankruptcy, do I still need to file an answer? So sometimes people will say, look, I've made the decision. I'm that unusual case where it makes sense to file bankruptcy, and I'm going to file bankruptcy in 2 months, so I'm not going to file an answer. Well, that's a really bad decision. You need to file an answer or get your bankruptcy lawyer to file an answer if you're filing bankruptcy. And sometimes people say, well, why? I mean, who cares? They get a judgment against me. I'll just wipe it out in the bankruptcy. Well, that's assuming that you qualify for a Chapter 7 bankruptcy. It's assuming that you qualify for any type of bankruptcy. Pretty strict rules now on who can file bankruptcy. And even if you can wipe it out, it's that judgment still exists. It's still on your credit report. So why would you have a judgment and then a bankruptcy when you could just file the answer, avoid a judgment, and then as soon as you file bankruptcy, then you let the court know, hey, I filed bankruptcy, and that will normally stop everything. So yes, definitely file an answer, even if you're confident you're filing bankruptcy. All right, so what does bankruptcy do to my credit reports? Well, it'll be reported on there that you have filed a Chapter 7 or Chapter 13 bankruptcy, and it stays on there for many years. And the accounts that are wiped out in bankruptcy, they will show that they have been discharged or included in bankruptcy. And they should show a zero current balance, because once you're discharged from your debts, you do not owe those debts anymore. All right, will filing bankruptcy help or hurt me to be able to buy a house in the future? This is a somewhat complicated question, where the answer is, and here's what I mean by this. Normally we'd say, look, filing bankruptcy is going to really hurt you in buying a house in the future. And that's absolutely true. There are a lot of types of loans that for a period of years you cannot even qualify for them no matter what else is going on financially. But there can be a situation where you're so overloaded with debt, maybe you've had your income drastically cut, and there's just no way out of it. Well, in that situation, you may not be able to buy a house anyway. So it's better to go ahead and do this extreme option of bankruptcy, pay the price now, and then once you get 2, 3, however many years it is for your particular type of loan, once you get that period of time passed, then you can qualify for that loan. So, will filing bankruptcy help or hurt me to buy a house in the future? It just depends. You need to talk about that and look at your unique situation and figure out for you, is this helpful or hurtful? All right, well, what about if we're not doing bankruptcy, but we say, I want to look at the option of fighting the lawsuit, but I do not want to hire a lawyer. I want to do it on my own. So let's talk about that. If you take this option, who will file your answer in court? Well, that's easy. You will file it. You don't have a lawyer to file the answer for you. So you file the answer in court. Kind of naturally leads to the question, well, how do I file my answer in court? Well, you file your answer in court by filling out the answer, and then you take that down to the clerk's office. So if you're in small claims or district court, you go to the district court clerk's office. If you're in circuit court, you go to the circuit clerk. And you give that to them. And I usually recommend take a couple of copies, get them to stamp those as being filed, so you have proof that you filed them. And then you keep one. I would scan it, get it up in the cloud, Dropbox, Evernote, Google Drive, email it to a Gmail account, just so you have it up there and you can prove that you filed your answer. And then send a copy to the other side, the collection lawyer that sued you. All right, can anyone help me in my trial if I'm doing this on my own? The answer is no. See, sometimes people say, well, look, my wife has been sued and she's going to represent herself, but I'm going to be there at trial and tell her what to say. I'm going to question the debt collector. Well, you cannot do that unless you're a lawyer. And if the husband's been sued, the wife can't be there helping him in trial. If you're doing this on your own, it means you are doing this on your own. Well, what can I do before a trial to get prepared? Well, there are some resources we can share with you. You can go to court, and we'll talk about this a little bit later, but go to your particular judge. Watch your judge, not the judge next door, but see how your judge conducts her courtroom. What does she say? Is it very formal? Is it informal? How does she handle things? Go watch your judge doing these exact types of cases so you can get an idea. And then, again, we've got some resources for you that you can look at and really prepare yourself. Understand how to answer questions. Understand what you need to prove and what you do not have to prove at trial. So, yeah, there are some definite things you can do before trial to get prepared. Now, what happens if you win your case? Well, if you win your case, then that normally means you do not owe that debt buyer any money on this particular debt. So Midland Funding sues you, says you owe me $5,000. You win your case. Guess what? You do not owe Midland $5,000. Well, what happens if I lose my case? Well, then you do owe Midland $5,000. And sometimes people say, well, I lost my case, but I don't really owe them. This was bogus, or I've got better evidence now, or the judge never should have let them come into court. None of that matters. If you lose, then you owe the money. Well, are there any tax consequences to trying the case on my own? Normally not. If you owe the money, in other words, you lose, well, then you got to pay it. Now, if you ultimately don't pay that, then there can be some tax consequences. But if you win, then that means you do not owe that money. So there's none of this what's called forgiveness of debt that can result in a 1099 being issued to you. If you win your case, then you do not owe Midland or Portfolio or LVMV or whoever it is. You do not owe them any money, so there's no money to be forgiven. Well, what about your credit reports? If you do this on your own, well, it's kind of the same thing. If you win, you do not owe Midland or whoever the debt buyer is, you do not owe them any money. So they should not be on your credit reports. But if you lose, then they can stay on your credit reports and you'll have a judgment now on your credit report. Well, what are the best types of cases to try on my own? Well, small claims can be good. That's kind of set up so that you do not have to have a lawyer. District court is a little more complicated, but that can be a type of case where you handle on your own. I'll tell you, the circuit court, very, very difficult. So if you think of small claims as being not terribly complicated, it's still a little complicated, but not terribly complicated. District court is multiples of that. Well, circuit court is many, many multiples of district court. Incredibly complicated. Lots of places where you could do everything right, but then you stumble in one area and you lose. So I would say the best types of cases are small claims in district court, and then it does depend on, well, what type of case, what type of defenses do you have, and so you have to start analyzing that on your own. All right, here's a question we're often asked. Do we have any resources that can help you? Yes, we do. Just contact us. Our phone number's on every slide, 205-879-2447, or you can always go to alabamaconsumer.com and just talk to us. And we can say, here are the resources we have, here are the advantages, disadvantages of them, and also talk to you about, for your particular type of case, does this make sense to do it on your own? And there's a lot of people we talk to and we say, you know what? In your situation, you should handle this on your own. Or maybe somebody says, well, I want to do it on my own. What do you think? And we go, yeah, it's a great idea. And then there are other people where we say, look, you can do whatever you want, but I think you're being pretty foolish if you do this on your own, or at least understand that you have a very low chance of success. All right, well, what about if you want to settle the lawsuit on your own? So you want to settle it, not fight it. You want to do it on your own, and you do not want to hire a lawyer. Do you still need to file an answer if you're settling your case? Yes. So here's a trap a lot of people fall into. Let's say you are served on the first of the month in small claims court. So how many days do you have? You have 14 days to answer. So you go, you know what? I'm not going to fight this. I want to settle it. So you're calling the lawyer. Maybe the lawyer's a little slow getting back. Maybe he calls you back and you're busy. And, before you know it, it's the 20th of the month. And you're still talking to them, still negotiating. And all of a sudden they go, we're not interested in talking anymore. You go, well, that's kind of weird. And then the next day you get a judgment in the mail where they have filed and received a default judgment against you. You go, wait a minute. We've been talking. See, it doesn't matter. You can talk all you want, but the clock is still running on your time to answer the lawsuit. And so file an answer, file your response, even if you're talking to them. And so this is similar to what we looked at in the last option. How do you file it? Well, you fill out the form, or you create your own form. You do that properly. You take it to the clerk's office. You file it in time. You keep some copies for yourself, and you send a copy to the other lawyer. So that's how you do it. And this is a very important question, because a lot of people are confused by this. They say, can I file an answer denying the claim, denying the lawsuit, but yet still talk to the collection lawyer about settling the case? Or do I have to choose one or the other? The answer is yes. You can file an answer denying the claim. It's what we just talked about in the previous slides. File that answer, and you can still talk to a lawyer. People go, well, wait a minute. I think if I talk to a lawyer about settling, that is me admitting that they own the debt. No, the courts encourage people to talk. That's confidential. And so the fact that you're considering paying them some money does not mean that you admit that you owe it. The fact they're considering taking potentially less than what they sued you for, does not mean they admit that it was a bogus lawsuit. So the court wants everybody to talk if there's interest in talking. So yes, you can file your answer and still talk to the collection lawyer about settling the case. So how do you settle the case on your own? Well, just in general terms, you talk to the collection lawyer, you negotiate a settlement with them. And when you get to the point where you agree to it and the collection lawyer agrees to it, now you can settle your case. Well, do you need anything in writing? Absolutely. You've got to have the terms of the settlement in writing. Now, writing can be an email, but do not make this mistake. You're sued for $5,000. You negotiate a $3,500 settlement with the collection lawyer, but you get nothing in writing, and you send them the $3,500, and then they still come after you for the other $1,500. They say, great, you owed $5,000, you paid $3,500, so you still owe $1,500. You go, no, that was a settlement. And they go, no, that was just a partial payment. And the judge is looking between the two of you going, well, do you have the settlement agreement in writing? You go, no. I thought if we did it over the phone, that was fine. They say the calls are recorded. And the collection lawyer says, well, we had a little glitch that day, and all the recorded calls were deleted for that day. So protect yourself. Put it in writing. Now, I'll say this about most of the collection lawyers I know. These are honorable people. They are not going to lie. But sometimes people have a misunderstanding and there's confusion over what was said. Don't take that risk. Don't put yourself in jeopardy. Instead, get it in writing so it's absolutely clear to everybody what the terms of the settlement are. Well, what's the difference in a lump sum settlement and a payment plan settlement? Well, lump sum is just money all at once. So go back to our example. You're sued for $5,000. They say, if you will pay us $3,500 in the next 30 days, the case is settled. Okay, that's a lump sum settlement. But if you go, I don't have that money, or I don't want to turn loose of that money all at once, they'll say, okay, well, how about you pay $500 a month for 10 months? So that's a payment plan. Or $250 a month for 20 months. That's a payment plan. Typically in a payment plan, you're going to pay the whole amount. In a lump sum, you pay a discounted amount all at once, and then the rest you do not have to pay. Here's something that we see quite a bit of. Why does a collection lawyer keep bringing up a consent judgment when we're talking about settling the case? Well, normally, although not always, but normally this is in the context of a payment plan case. And the collection lawyer will say, we can take $250 a month for the next 20 months. But we're just going to need you to sign this little document. It's just something called a consent judgment. Well, what they're wanting you to do is sign this document, and then they take that to the judge, and the judge enters judgment against you. So remember earlier we talked about a default judgment. This is a consent judgment. So what is a default judgment? That's where we default. Well, what's a consent judgment? It's where we consent. We agree to the judgment. Somebody says, well, why in the world would I agree to a judgment? That's a great question. There's no good reason to agree to it. But here's the argument from the collection lawyers. They say, well, you promised to pay us $250 a month for 20 months. How do we know you're going to pay it? What if you stop paying? We want this consent judgment so we can start garnishing your wages, your bank account, do a sheriff's sale on your home. And this is our leverage, our protection. And look, from their perspective, it makes perfect sense. But from your perspective, that's a real judgment. So if you're asked, do you have any judgments against you? Yes, I do. It'll show up on your credit report. At least if the credit bureau picks up on it. It's a real judgment, just like a default judgment is a real judgment. My personal view is, I don't think you should ever agree to a consent judgment. Obviously, if you represent yourself, which is what we're talking about, you have to make that decision. But I think consent judgments are terrible, and there are much better solutions to this. So if they say you have to agree to a consent judgment, again, you decide what you want to do, but you may want to say, no, I do not agree to that. All right, well, how does the case actually end when I settle it? Well, it ends with a dismissal. And what I recommend you're looking for is a dismissal with prejudice. And normally we think of prejudice is not a good thing. Here, prejudice is a good thing. It means it's over, it's final, it's finished, it's done. That's what you're looking for. Well, what about tax consequences? If I settle my case, are there any tax consequences I can face? The answer is yes. Now, typically, if you're doing a monthly payment plan, you're paying off the whole amount, there will not be any tax consequences because usually there is nothing, quote, forgiven. But if you do a lump sum, to go back to our example, $5,000 lawsuit, and you settle for $3,500, that's a lump sum. Well, assume the debt collector, the debt buyer, is going to report to the IRS that they forgave you the difference, be $1,500. Well, what does that mean? Well, that typically means that's $1,500 of income that you now have to pay taxes on. Now, I'm not a tax attorney. I'm not giving you tax advice. You've got to figure this out. But I just want to alert you to this because people get this very nasty surprise. So they're sued in February and they settle. Let's make it bigger numbers. They're sued for $10,000. They settle for $6,500. And then the following January, they get a 1099 from Midland Funding for $3,500, which is going to cost them quite a bit in taxes. They're going, wait a minute, I thought I was done with that. Well, you were done with the settlement, but not the tax consequences. So make sure you understand the tax consequences if you're settling a case on your own. Well, what about settling? What does that do to my credit reports? Well, go back to our example we've been using. You're sued for $5,000. Midland Funding's on your credit report for $5,000. You pay them $3,500. Well, if you do that, once the case is over, once you've paid that money, then how much do you owe Midland Funding? I think the answer is zero. Now, a lot of times we'll see these debt buyers, they'll put your current balance as $1,500. So you take $5,000 minus $3,500, and they go, yeah, you owe me $1,500. No, I owe you zero because I settled this with you. I paid this. We did a lump sum settlement, but it's over now. But understand, it'll still be on your credit report, and you want to make sure it's a zero balance and that it's not reporting that you still owe more money than you do, which again, if you settle it, zero balance. It's a little more complicated when you're doing a payment plan. When do they have to update that? When do they have to lower the balance? But just understand, settling can definitely have an impact on your credit reports. And sometimes when you settle, it has at least a temporary reduction in your credit score. Kind of bizarre, huh? But the idea is this is recent activity. And so just be aware, settling can definitely have an impact on your credit report. All right. Well, what if you say, you know what, I want to look at the option of hiring a lawyer to fight the case. So this would be a natural question you would want to ask. If I hire a lawyer, how will I know if I have a good chance to win the case or not? It's a great question, and it's a little bit challenging in this sense. You're in a new world here. You're in court. You're in a lawsuit. And so you're hiring somebody who is a professional in this. So in a lot of ways, you have to trust that professional. You need to ask them, hey, what are my chances of success? Now, quite likely they will ask you questions about, do you really owe the underlying debt? When's the statute of limitation? What have you received from the debt collector? All sorts of questions a lawyer will ask you to then be able to give you an opinion on, hey, what are our chances of success? Now, this is my view. If the lawyer says, well, I will not answer that question. I cannot guarantee you whether we will win or lose. So yes, I understand you cannot guarantee whether we'll win or lose, but you can tell me if you feel good about it. You can give me some odds, and if the lawyer says no, then you have to decide if that's the right lawyer for you. Well, speaking of hiring a lawyer, how about hiring somebody who has never defended a collection case? Hey, it's your choice. You can do that. And everybody has to have their first case. But the question is, do you want to be the first case for that lawyer? And that's something you have to answer. Now, maybe the world's greatest lawyer, and they are far superior to every other lawyer. They just have never handled one of these cases, but they could do the best job possible for you. Great. But you have to make that decision if you feel comfortable hiring a lawyer who has never defended one of these cases before. Certainly, it's a question you should ask. Hey, have you defended these cases in general? How about with this specific debt collector or this specific collection attorney? Have you defended these types of cases? Well, how do you tell if you found the right lawyer? Here's my suggestion. You really cannot tell in an objective way whether the lawyer is the perfect lawyer. Okay? And matter of fact, ethics rules prevent us as lawyers from saying, hey, I'm better than some other lawyer. But that's a decision you have to make. And it's very hard to determine the skill of the lawyer directly. And here's kind of a dirty little secret. I do not know if the criminal lawyer down the street is a good lawyer or not. I have no idea. I'm not a criminal lawyer. I'm really good at personal injury. I'm really good at consumer litigation. I do not know if the criminal guy is good, or the mergers and acquisitions lawyer, or the lawyer is going to draft your corporate documents. I don't know if she's any good because that's not the area I practice in. And so it's really impossible for you, not being a lawyer, to know whether a particular lawyer is going to be great at defending these types of cases. But here's what you can do. You can decide, do you feel confident and comfortable with this lawyer? Does this lawyer answer your questions? Does this lawyer give you information? What does this lawyer do so that you go, this is the right person for me? Same way picking a doctor, right? You don't know if that doctor, how steady is his or her hand in the surgery. But do you feel comfortable with them? Do you feel confident? Have you had family members? Have you read reviews? You just do all your common sense things to figure out, is this the right person for me? And once you find the right lawyer, then you say, okay, well, how much is this going to cost? And I can't tell you on here because it's going to depend on your particular case. But let me give you some ideas. Is a lawyer charging you an hourly rate? If so, what's the amount? And how many hours are they going to spend on your case? Is this a 1-hour case or a 101-hour case? Big difference. Does a lawyer use a flat fee or a fixed fee? In other words, it's X number of dollars. Well, what does that include? Can it go over that? Now, I'll just tell you, I can't think of any exception. We always use a flat fee on these types of cases. And clients will often say, well, what if it gets more involved than you thought? Will that go up? Or what extra do I have to pay? And I go, well, you don't pay any extra. It's a flat fee. It's X number of dollars. That's all it will ever be. Whether the case gets resolved 1 minute after you hire me or 5 years after you hire me. And people are kind of puzzled by that. They say, well, I did this one time with a lawyer and that flat amount, fixed amount ended up growing. Well, then it's not flat, it's not fixed. A fixed amount means that's exactly what it's going to be. So make sure you know how much that is. Will the lawyer file the answer for me? Well, yeah, if you're hiring the lawyer, they'll file the answer for you. To me, it would be odd to hire a lawyer to fight the case for you, but yet you're still responsible for filing the answer. I suppose that's technically possible. It just seems odd to me. I'm not sure why you would do that. Well, what about if you have already filed your answer and then you say, I think I want to get a lawyer involved. Can I hire a lawyer after I file my own answer? At least with my firm, the answer is yes. This happens quite a bit. People are still looking at their options. Maybe they're undecided. They file their own answer. Or maybe, particularly as they get really close to trial, they go, oh my goodness, I need somebody to help me. So, the complexity or the danger is, what if the lawyer is busy on the day of trial? That may prevent you from hiring that particular lawyer. So I would get with the lawyer as soon as possible. They can check their schedule, see if they can represent you, and obviously still find out what's the cost. Is it fixed? Is it a hourly rate? What is this? All right, do I need to be at trial if I have a lawyer representing me? The answer is it depends. And I'll just tell you what my practice is. We do not have our clients at trial unless there's something you can do that will help you at trial. Kind of makes sense, right? So if there's something we need to prove, so for example, if let's assume statute of limitations is 6 years and you know that you have not made a payment in 8 years. But the debt collector says, oh, no. You made a $20 cash payment to us 6 months before we sued you. You just mailed us cash in an unmarked envelope, but we figured out it was you, and so that restarts statute of limitation. Well, I would want you to be at trial to testify, no, I haven't made a payment in 8 years. But normally we do not need our clients at trial. Now, if you're subpoenaed, you have to be there at trial. Other lawyers may handle it differently and say, no, I want you to be there at trial. So that's a great question to ask the lawyer that you're considering hiring. hey, when it comes time for trial, do I need to be there? Some people want to be there, but 99% of people do not want to be there. And so they're very comforted by the fact that we do not want them to be there unless, again, there's something unusual where we need your testimony to help us at trial. Will my lawyer keep me up to date on the lawsuit? Well, I certainly hope so. And that is something you should expect, and you should demand that you be kept up to date on the lawsuit. And ask the lawyer, how will you keep me up to date? Now, some lawyers may say, well, you can call in when you have a question. And certainly you should always be able to call in when you have a question. I'll tell you the way that we do it is when something happens, we notify you. A lot of people use email, so we do that by email. We send you the court documents. Some people want them mailed to them. Some people want us to call them when something's happened. And then certainly you can call in, speak with Carolyn in my office, and she can talk to you about here's what's going on. And you can always set up a call with me. But our job and what our goal is to keep you up to date so that you're never sitting around wondering. Now, sometimes there are long periods of time, and so it may be, hey, nothing's happening. I don't expect anything to happen for the next 30 days. We'll touch base with you if something does happen, or in 30 days we'll touch base and say, hey, nothing's happening right now. Because that's just part of the joys of a lawsuit. But you should definitely want your lawyer to keep you up to date, because otherwise you're going to be stressed out about this, worrying about what's going on with the lawsuit. All right, what happens if you lose the case that you hired a lawyer on? Well, that's possible. Whenever there's a trial, somebody is going to lose. So if you lose and you have a lawyer, it's the same thing as if you do not have a lawyer. You will have some options on appeal, and we'll talk about those in some later questions. But ultimately, if that loss stands, so in other words, you don't appeal or you lose your appeal, then it means you owe the money. Well, what about if you win the case? Well, again, it's the same thing. Whether you have a lawyer or do not have a lawyer, if you win the case, then that normally means you do not owe the debt to that debt buyer. And now, whether you win or lose, having a lawyer will certainly help you in understanding your options. Okay? So, if you lose a case, well, can you ask the judge to reconsider it? Can you appeal? If you win the case, what does this mean for the collection company on the other side? Can they appeal? What can they do? And having a lawyer will definitely help you to be able to understand those options very clearly. What about tax consequences? So if you hire a lawyer to fight the case, well, again, it really does not make any difference on fighting the case about taxes, whether you do that on your own or with the lawyer. If you win the case and you do not owe the money, well, there should be no tax consequences. If you lose the case, then you've got to pay the money. Now, if you don't pay it and some of that debt is forgiven, that could have tax consequences for you. All right, well, what if you want to hire a lawyer to settle the case? You say, I don't want to go to trial. I want to settle this case. And I don't want to do it on my own. I want to get a lawyer to help me. How much will it cost in lawyer fees? Well, again, that's a great question. You need to know that very specifically. Just like hiring a lawyer to fight it, you want to know, is this hourly? Is it a percentage of what you're saving me? Is it a flat fee, a fixed fee? What is your fee? And again, in these type of cases, we do a fixed amount. So you know exactly what it's going to be. And so you're not wondering, well, I wonder how much it's going to cost. You know exactly what the cost will be. So you can decide if this makes sense for you to do. Well, do I need to file my own answer if I've hired a lawyer? Again, if you've hired a lawyer to settle the case, it would be odd to me if that lawyer did not also file the answer. Certainly, we have people hire us and they say, hey, you have authority to settle the case, but we go ahead and file the answer because we do not want that answer to not be filed, and then there's a default judgment against our client. So make it very clear, whoever you hire as a lawyer, are they filing the answer for you? Well, how much will I have to pay the debt collector who sued me? So I've hired this lawyer, paid this lawyer some money. How much do I have to pay the debt collector? Well, again, ask your lawyer. say, what are we going to have to pay to settle this? I'll tell you, our position is, and I'll just make this very simple how we do it. People hire us really to fight it and to settle. And here's what I mean by that. It's a flat fee, and we say we have authority to settle it if you pay absolutely nothing, not one penny to the debt collector. The debt collector comes off your credit report, and what you, quote, pay is you agree not to sue the debt collector. Those are our terms of settlement that we use. And so the answer to this question, how much will I have to pay a debt collector? Zero, if we're representing you. If this is a live lawsuit, in other words, you haven't already had a judgment against you, we're not going to pay the debt collector any money if they want to settle with us. Now, sometimes people come to me and say, John, I want to hire you in this case. I want you to pay the debt collector money. And I go, I don't do that. I'll get you to another lawyer who will do that, but I am not paying them any money. And so just be very, very clear, whoever you're hiring, are you going to pay the debt collector money, and how much are you going to pay? So you can figure out the total cost to get this case settled. Well, this is a question that I've heard this several times, and it's so bizarre to me. And so I imagine if I've heard it, then a number of people have been faced with this situation. Here's the bizarre question. Why would my lawyer make a settlement proposal and tell the collection lawyer I want a consent judgment? I have no earthly idea. That's the dumbest thing I've ever heard. If you're settling, and these have been in the context of a lump sum settlement where the client ends up not hiring the lawyer. They, come to me later and they say, my lawyer said $5,000 lawsuit. He wants to propose $3,500 with a $3,500 consent judgment. And I'm going, why in the world? That makes no sense to me. You never, in my opinion, want a consent judgment. And if you're doing the settling, it's the collection lawyers that want the consent judgment. We don't want it. I have no idea why a consumer lawyer would say, hey, I think I want a judgment against my client. That's just bizarre. So if that ever comes up, I would just ask, why in the world would you suggest this? Explain it to me. All right, will there be a written settlement agreement? Absolutely. You've got to have a written settlement agreement, just like if you're doing this on your own. We talked about it a few slides back. But if you hire a lawyer, you certainly want a written settlement agreement so it's very clear what are you doing, what are you paying or giving up, and what is the other side agreeing to. So again, in our settlements, we make it very clear the lawsuit will be dismissed with prejudice. It's coming off our credit report. In other words, the debt collector is not going to be on our credit report for this account. And we pay them nothing. And we agree not to sue them. So think of it as sort of global peace between you and the debt collector. That's what we're looking for. So we want that to be very clear in the settlement agreement. And so, again, if you're talking to a lawyer and they say, hey, I hope you settled this, say, will there be a written settlement agreement? Now, sometimes it's very, very formal. It's notarized by a notary public. Other times, it's an email exchange between the lawyers. That's fine. You just want it to be written and clear. We have any tax consequences if you settle? Well, again, it's basically the same whether you have a lawyer or don't have a lawyer. Is there any forgiveness of debt taking place? That's really the important point to tax consequences. So if you hire a lawyer in a $5,000 lawsuit to settle the case for $3,000, yeah, you better assume you're going to get hit with $2,000 of income. That's the difference between the 5 and the 3. Now again, in our the approach we take is we will not pay these guys any money, not one penny. And a big part of that is I do not even want the possibility of the argument that, oh, we forgave this consumer the debt. So imagine a $20,000 lawsuit and we say, let's pay them $2,000. Well, they've got an argument, whether right or wrong, they have an argument that they have forgiven $18,000, right? 20 minus 2 be 18. Well, it's kind of hard to argue they forgave us any debt if we paid them $0. So let's kind of think this through. Hey, they sued me for 20 grand. I filed an answer. Remember, we always file an answer denying that I owe Midland or Portfolio or LVMV or whoever it is. I deny I owe them any money, and I pay them nothing, and they drop the lawsuit with prejudice, which is really a judicial determination that I do not owe that money. So how could they possibly forgive any? That's been our position for many, many years. We've never had any problems with it. But again, if you're thinking about hiring a lawyer to settle a case, you need to know from that lawyer, what can the tax consequences be? Okay, well, what happens to my credit reports after I settle? So you've hired a lawyer to settle the case. What's going to happen with your credit reports, with Midland or Portfolio, whoever it is, with their credit reporting on you? Well, again, you need to know this before you hire the lawyer. What's the plan? Again, the way we do it is we want the credit reporting deleted by the debt collector. But other lawyers may say, no, I don't care about that. And you need to know that going in so you make sure that whatever it is you're wanting to happen actually happens. And what you're paying for that you get. And then I would ask the lawyer, how will we make sure that whatever the deal is on the credit reporting, that is actually followed? And the lawyer should have a good answer for you on that. And we have a whole follow-up system on that, but just ask whoever you're talking to about that. Okay, well, what is the purpose of the answer? Well, let's think about what's the purpose of the complaint or the lawsuit. It's to say, here's the debt you took out, here's how you did not pay it back, and the debt collector will say, and now we bought it, and so you owe us the money. So your answer is your response, or where you answer those allegations. So you're telling the court, either I agree with what the complaint said, or I disagree with it. And if I have any what are called affirmative defenses, that's a defense where you say, well, maybe the plaintiff, the debt collector who sued me, is right, but I still win because of, for example, statute of limitations. All right, so if I represent myself, how do I file my answer in court? And we talked about this a little bit earlier. You would prepare the answer, and then you take it to the clerk of the court. Now, some people will mail it in. I would prefer you physically take it so there's no question that it actually gets filed. In other words, you mail it and it gets misdelivered or it goes to Wyoming instead. That's not the court's fault. It's not the debt collector's fault. Unfortunately, it's your fault because you have the obligation to make sure your answer gets filed. So I would physically take it to the courthouse, to the clerk of the court, and file that answer in. All right, is there a form answer in small claims court? Yes. Matter of fact, when you are served with the lawsuit, you'll have that statement of the claim or the complaint, and then you should have an answer, a form answer. It's already got the case number, it's got the name of the case, and you just have to pick between 4 boxes, A, B, C, D. And so you should have that. And I'll just go over those real quick. Box A is, hey, you sued me in the wrong county. Box B says, I admit I owe everything, enter judgment against me. Box C says, well, I owe some but not all. And box D says, I deny owing. And if you're doing this on your own, you have to decide what to do. I'll tell you that the typical way to do this is you check box D unless you somehow know that that old Synchrony Bank debt is now owned by Portfolio Recovery or Midland Funding. I'm not sure how you would know that. That's a secret transaction between these companies. But if somehow you know that, then maybe you do not check box D. But anyway, it's something for you to consider if you're doing this on your own. But there is that form answer in small claims court. Well, is there a form answer in district or circuit court? And the answer is usually there is. Different courts are run it a little bit differently, but there is kind of a generic form answer out there, and you can search for that, and it's kind of a fill in the blank type of thing. But understand this, the concept of the answer is, do you admit or deny what the other side is saying? And so that can be handwritten. I deny I owe the plaintiff any money. Statute of limitations has expired. You could handwrite that. And so that's the substance of it. Now, kind of wrapped around the substance of it is, have you made it clear what case this answer belongs in? So how do you do that? Across the top, you put, hey, this is in the District Court of Jefferson County or the Circuit Court of Mobile County. And then you put the case number. And you put the names of who the parties are, who sued you, Midland Funding, LVMV, Portfolio, Cascade, Velocity, whoever it is. You put your name so that the clerk of the court can get your piece of paper and go, oh, I see. This goes in the Midland Funding versus Susan Smith file, 2017 small claims case number 134. Perfect. That's what you want. So you can look for a form answer or you can do it on your own, but the bottom line is there's no magical form you have to use. It's the court's looking at the substance of it and just make it very clear which case it goes in. What if I hire a lawyer? Will the lawyer file the answer for me? I would certainly hope so. And now again, it's possible, I suppose, that you could hire a lawyer for what's called a limited scope representation, where they're not going to file an answer for you. But honestly, I don't see any reason to do that. If you're hiring a lawyer, make sure you know that they're going to file the answer, and then make sure they actually file the answer for you. Well, what should you put in your answer? Well, I can't tell you because I don't represent you, and I don't know your unique situation. But again, conceptually, you're putting in there whether you agree or disagree with what the plaintiff, the debt collector who sued you, what they are saying. And if you have any defenses, for example, statute of limitation defense, have you put that in there? Okay. And so the idea is so that the judge can look at the lawsuit and then look at your answer and go, is everybody agreeing here? Because some people say, I admit everything. Well, then you're going to get a judgment against you. But if you say, I deny this, then the judge is going to say, okay, well, now we need to proceed toward trial on this. All right, well, what happens before a trial in small claims or district court? So we're talking about everything up to the trial in those two lower courts, small claims or district court. How will I be notified of the trial date? Well, you typically either get a letter or an order or almost a little postcard looking thing from the court that says, here's when your trial date is. Now, very important, you be looking for that. Okay? You're not going to get it by certified mail. No sheriff's deputy is going to hand it to you. And sometimes people say, well, I think that a sheriff's deputy should bring out the trial date to me. Yeah, that's not happening. They're going to mail it to you. And the thing is, if you don't get it, they're still going forward with court. Now, maybe later you can explain to the judge, and maybe if you're within the very strict time limits, the judge will undo a default judgment against you. But here's my suggestion. When you file an answer in small claims or district court, typically you're trying your case in 4 to 8 weeks, so 1 to 2 months. So I would be on the lookout for anything from the court, anything from the collection lawyers. If you live alone, make sure you go through every piece of mail. Okay? If you have family members, tell them, do not throw anything away in the mail until I look at it. Because look, it sounds almost like a joke, but this is real. The trial notice could be stuck between the Pizza Hut and the Captain D's coupons. Okay? And if you just throw those away, you may have thrown away your trial date. Well, guess what? If you don't show up at your trial date, what happens? Default judgment. So if you aren't seeing the trial date, I would call the court. Say, hey, I filed my answer, a week ago. I just wanted to check and see, do we have a trial date? I do not want to miss my trial date. And then they can look it up for you. Now, obviously, if you have a lawyer, the lawyer is going to handle this for you. Okay, well, what happens if you get the trial date and you realize, I need to change this? Well, if you have a lawyer, you let your lawyer know and he or she will handle it. But if you're doing it on your own, I would get with the collection lawyer, see if they agree to moving the trial date, and then you have to file what's called a motion to continue. A motion is just a request of the court, and that's done in writing. And to continue the trial date just means to change it. And so here's my suggestion. Don't wait till the last minute. I mean, there are people that will call the collection lawyer who's driven 2 hours for trial, for a 9 o'clock trial. They'll call him at 8:55 and say, yeah, I'm not going to be able to make it. I need to continue it. Well, you can imagine the collection lawyer, unless there's some really bizarre circumstance, like, you're in an ambulance, is going to say, no, I drove 2 hours. You're not calling me at the last minute. At least I'm not agreeing to do this. So as soon as you know you need to change that trial date, get with the other side if you're doing this on your own. If you have a lawyer, just get with your lawyer, tell your lawyer, and they'll handle it. Well, what about what happens before a trial in circuit courts? There's some similarities, but it can be a little different than small claims or district court. So usually there will be something called a status or scheduling conference. And what this means is, well, let me give you kind of the more precise definition. A status conference is where the judge says, okay, what's happening? What kind of case is this? Where are we? Are we ready for trial? How much time do you need? A scheduling conference is usually just the last part of that, where the court goes, okay, when can we try the case? What are the deadlines that everybody's going to have to live with? And so we don't normally have that in small claims or district court. You just get the trial date. But usually in circuit courts you have, and different judges call it different things, a status or a scheduling conference to set the deadlines. Well, what is discovery in a collection case? We definitely do not have discovery in small claims. It's very rare in district court, but in circuit court, very common. Discovery is where either side can ask the other side questions in writing. These are called interrogatories. Think of it like an interrogation, but in writing. Either side can send requests for production of documents. So you might say to portfolio recovery, hey, I want all of XYZ documents. They can say to you, we want all these documents. You can have what are called requests for admissions. These are probably the most dangerous things for people representing themselves, or for lawyers who just don't do litigation, don't do lawsuits. A request for admission, for example, will say, admit that Midland Funding purchased the debt. Admit that you owe Midland Funding this money. Admit that Midland Funding is now the owner of the debt. Well, a lot of people get these, they go, I'm not answering this. This is stupid. I'm just going to wait till trial. Well, the problem is that if you do not properly answer requests for admissions, you admit them. That's a fact now. So discovery is very important. We have this what's called paper discovery that I've mentioned. Those would also include subpoenas. That's where you're asking somebody who's not a party to the lawsuit to provide documents or testimony. And then we have depositions, where somebody can ask you questions under oath with the court reporter. So that's what discovery is in a collection case. Do you have to answer discovery? Absolutely. If you do not answer those requests for admissions, you admit them. If you do not answer the other types of discovery, there can be sanctions or very serious consequences to you, including you could even lose your case because you do not answer the discovery. So you got to answer them the right way in the right time. Now, if you have a lawyer, the lawyer will help you with this. If you're doing it on your own, which I don't recommend in circuit court, but if you find yourself in that position, you have got to follow all the rules on discovery. Because even though you don't have a lawyer, the judge is going to expect you to have the knowledge of a lawyer. All right, what happens if you don't answer discovery properly? Well, we've talked about that. You can lose your case. I mean, think about those requests for admissions. It says, admit that portfolio recovery now owns this debt, and you do not answer it, or you admit it. Same thing. You've now established as a fact portfolio recovery owns the debt. So when you get to trial and you go, yeah, but judge, they don't own the debt. They pull out those requests for admissions and say, Susan or Bob or whatever your name is, you admitted they own the debt. So bottom line is you can lose your case by not answering discovery properly. And again, you'll read stuff on the internet, people say, you don't have to answer that, that's unfair. No judge will expect it. Well, I'll tell you, every judge I've ever been in front of in Alabama and circuit court, they expect their discovery to be answered and answered properly. And there are very serious consequences, as you can imagine, if you do not answer it properly. Well, what is a summary judgment motion? So think about it this way. A summary judgment motion is a request that the judge summarily enter judgment against you. And the concept is, Judge, there's no way the consumer can win. So there's no point having a trial, whether it's a bench trial where it's just the judge or whether it's with the jury. If there's no way the consumer can win, then why go through that time and expense? And so this is the argument from the debt collector. Just go ahead and enter judgment against them. So think back to what we've talked about, different types of judgment. If we don't answer or we don't show up at trial, what's that called? A default judgment. What if we agree to a judgment and a settlement? That's a consent judgment. Those are real judgments, 100% legitimate judgments. A summary judgment is 100% legitimate. Sometimes people say, oh, well, I don't believe in these summary judgment. I'm not going to respond. I'm just going to show up at trial. I want my day in court. There is no day in court if you lose summary judgment. Or stated differently, that is your day in court. People go, no, I want a trial. Well, you don't get a trial if you lose summary judgment. So it's very, very dangerous. Critical that you understand this. So do you have to properly respond to a summary judgment? Absolutely. If you do not, you lose your case. And people say, well, I don't know about all those rules. I'm not a lawyer. There's a hearing set for summary judgment. I'm just going to go there and argue my case. And I print some stuff off the internet, Midland Funding or LVMV. These are bad companies, and that's all I need to tell the judge. You're going to lose. You have to respond properly under the rules. And I'm not going to get into all those rules because I kind of hesitate to say, well, here are 3 of the 8 rules. I mean, you got to know all the rules on summary judgment. The timing. When do you have to respond? How do you respond? What format do you respond? What type of evidence do you need? What format does that evidence need to be in? You've got to know all of that if you're dealing with summary judgment. Now, if you have a lawyer, presumably your lawyer knows how to handle that. But if you're doing it on your own, just understand this is probably the most dangerous moment in the lawsuit, because out of the dozens and dozens of situations where people have tried to do this on their own, maybe one I can think of where they did not lose. I mean, this is almost guaranteed that you will lose summary judgment if you're doing this on your own. What happens if I lose summary judgment? It means you lose the case. There is a judgment entered against you. And then we start all those things we started off with. Wage garnishment, bank garnishment, seizing your property, including your home, selling your home, wiping out bank account. I mean, just all this bad stuff goes on your credit report. It is a real judgment. So you want to avoid a summary judgment. Well, what's a pretrial hearing? Well, this is a hearing where the judge wants to talk to both sides or their lawyers before the trial. It might be a month before, it might be the Friday before a Monday trial. And typically the judge will say, hey, are there any issues, anything I need to rule on? How long will this take? How many witnesses are we going to have? It's where the judge just kind of gets a game plan for what's going to happen in the trial. Here's something that's very critical. Usually in the pretrial order, and sometimes the pretrial order comes out before the pretrial conference, so it can get a little confusing, but there can be an order, sometimes called a scheduling order, that will say, look, 14 days or 21 days or 7 or 30, whatever it is, so many days before the trial, you have to disclose your witnesses and your exhibits. What happens if you do not disclose your witnesses and exhibits? Normally, you're not allowed to present any. Now, you have to think about and really understand, do you need any witnesses? Do you need any exhibits? at your trial. If you're the defendant, you've been sued by the debt collector. And I leave that up to you and your lawyer. I can tell you, when we represent people, it's pretty rare that we have witnesses and exhibits. And there are some reasons which I won't get into on this public video. But if you want to have witnesses and exhibits, and you need them, and you do not properly disclose them, you may be prohibited. And again, people go, well, that's not fair. I brought 5 witnesses with me to trial. Judge says, well, did you follow my order? No, but look, my witnesses are here. She may say, they're not speaking. Yeah, but I got this whole stack of exhibits. Well, if you did not disclose them, the judge may say, they're not coming into evidence. So make sure you follow all the orders in court. Well, let's talk now about just some general questions about trials, and then we'll get more specific as to the type of court you're in. Okay, what about this question? Should I go watch a day of trials in front of my particular judge for a trial day? Absolutely. Now, it's easier in small claims in district court because I have tons of collection cases. Circuit court, more difficult. But you want to see, how does your judge react in a courtroom? Some judges are very formal. Some judges are pretty casual. Some judges don't want anybody talking. Some judges don't care. Some judges walk out and they expect everybody to stand, and we'll talk about that later. Other judges are like, no, keep your seat. So you just want to know, there's no right or wrong answer. You just want to know, for your judge, what is your judge like? Let me tell you kind of the hidden reason also that I want you to do this. I want you to know where the courthouse is, if you're doing this on your own, where the courthouse is, how to get through security, where your judge's courtroom is. And that sounds silly, but here's what I say. I've had a lot of people contact my firm. They got sued, they filed their answer, they show up to court, and they sit in the wrong courtroom. Sometimes they sit in a dark courtroom. The lights are off. They're just sitting there. Other times, there's multiple judges in the courthouse, and each courtroom might have 100 people in it, and they just happen to get in the wrong courtroom. And so when their case is called in courtroom number 2 and they're sitting in courtroom number 1, they don't show up. And that collection lawyer may not say, Judge, let me go check the other courtroom. You don't show up, what happens? You lose. So I want you to know, absolute confidence, I know exactly where the judge, I know what the judge looks like. I know the courtroom number, so that on the day of your trial, you have that part down. And see, when you go, when it's not your trial, you're just watching, there's no pressure on you. You just get to observe. How do people speak? How do they stand? What looks effective? What looks like it's not very effective? Do that before, so that when it's your day of trial, you'll be much more comfortable. All right, so this is important to know. Why does the collection lawyer want to talk to me in the hallway right before my trial? A lot of times what will happen is the judge will call the cases. He'll say Midland Funding versus Smith, and the lawyer for Midland Funding will stand up, you'll stand up, and judge will say, now y'all are free to go talk. We'll take a break here in a minute. And the lawyer will say, can we go out in the hallway and talk? They're wanting to talk to you about settling the case. Now, you have the right to chat with them. You have the right to settle. You have the right to not settle. That's up to you. Now, obviously, if you have a lawyer, your lawyer is going to be there with you. But that's why the collection lawyer wants to talk, is to see, can we resolve this before the trial? All right, if I go talk to the collection lawyer, does that mean I agree I owe the debt? No, but I hesitate slightly because people can mess this up. So the lawyer says, all right, we've sued you for $5,000. What can you agree to pay? If you say, well, I could pay X dollars, you are not admitting you owe the debt. But now you may say, I admit I owe the debt. Well, that may be used against you, whether properly or improperly. If you don't settle it, the lawyer may say, well, now out in the hallway, you admitted to me you owe this debt, don't you? And you admit you owe it to us. So I would not make any admissions unless you have thought this through very carefully. So the fact that you go out there and talk and the two of you kick around some numbers, that doesn't mean that if there's not a settlement, that somehow the collection lawyer is barred from getting the full amount. So let me put some numbers on that. You're sued for $5,000. The collection lawyer says, well, we would take $4,000, and you don't take it. Well, then when the collection lawyer says in trial, you owe me $5,000, you can't say, in the hallway you said $4,000. It doesn't work that way. Same thing if you offer $3,000 and they turn it down. They can't say, well, you admitted you owe it because you offered us $3,000. No, we want to encourage settlements. So just be careful as you talk to the lawyer about not admitting you owe Midland Funding, Portfolio, whoever it is, unless that's what you really want to do. All right, what's a consent judgment? If you've been watching this whole video, then you know a consent judgment is where you agree to a judgment. You consent to it. I think these are terrible. If you have a lawyer, your lawyer will help you with it. I mean, if we represent you, I can just tell you, we're not agreeing to a consent judgment. But if you're representing yourself, then you have to decide, do I want to agree to a consent judgment? And better make sure you understand that and understand what the consequences are of a consent judgment on your credit report, on getting loans in the future, what that might do with your job. Just understand what is a consent judgment, because it is a real judgment. All right, will the judge swear me in before I testify at trial? The answer is yes. The judge will have you raise your hand, do you swear, affirm, tell the truth. And so anybody who is testifying, so not talking about the lawyers, but anybody that's testifying will be sworn in before they actually give their testimony at trial. So should I bring witnesses with me to trial? Well, that depends. Do you have witnesses that can help you win your case? If you do, then sure, bring them. Assuming you properly disclosed them, if you have to disclose them. But I would just caution you to think it through. If you're doing this on your own, what witnesses can help me win my case? And make sure that you have a clear understanding of that, and that you're not bringing somebody that will actually hurt you in the case. All right, so what should I take with me to trial? And on all of these, I mean, if you have a lawyer, your lawyer will tell you. When we have clients, there's nothing that they bring to trial, because you have to assume if you take something into the courtroom, the collection lawyer can ask you about that. But if you're doing this on your own, you need to ask yourself, okay, well, what do I need to help me at trial? Do I have exhibits that I want to get introduced into evidence? Do I have notes? And just think it through. Is this helpful or could it be harmful to me? And then you make that decision. All right, when I'm asked questions from the collection lawyer, should I answer them? I have seen people that the collection lawyer asks them a question, they go, Judge, I refuse to answer this lawyer. He's a collection lawyer. That's not how it works. The collection lawyer is entitled to ask you questions, and unless the question is improper, then you need to answer it. Well, what should I do if I don't understand the question that the collection lawyer asked me? Well, here's my rule. Now, again, if you're doing this on your own, you have to decide what to do, but I think it's a really good approach, is if you do not understand the question, then do not answer it, because you promised to tell the truth. And if you go, I have no idea what this lawyer asked me, how do you know you're telling the truth? Back it up a step. If you don't hear the question, how can you answer it truthfully? So if you do not hear the question, if you do not understand the question, my suggestion, the way that my clients respond is they say, I'm sorry, I did not hear that, or I do not understand that, or what do you mean by this word? Or maybe it's just a really confusing question. They say, I just don't know what you're asking for. Can you rephrase that? And if you're doing that in a legitimate, honorable way, the lawyer's not going to mind. And if they do, the judge is certainly not going to mind, because you're taking your obligation to testify truthfully very seriously. And that is mission critical. So if you do not understand the question, then you have the right to say, I'm sorry, I do not understand that. Can you rephrase that? Should I only answer the question asked, or should I do more than just answer the question? Let me give you the context of this. When you are asked a question and you want to do this, you want to say yes, but, or no, but, that is where you are answering more than what's been asked. So let me give you sort of a silly example. So your spouse says, hey, on your way home, will you grab some milk? And you blow right past the grocery store. And you walk in the door, your spouse looks at you, and they say, did you get the milk? Well, what are the only possible answers? Yes, no, I don't remember, I don't know. Okay? Now, the truth is, the answer is no. But we feel a little hesitant about that. So we say, no, but I've been thinking, why do we feed our kids milk from some animal? Or why would adults drink milk? That just makes no sense. And you start going down this long tangent, and your spouse is sitting there going, I just asked you if you got the milk. Okay, that's the question. So when you want to start explaining it, and typically the way you do that is you say yes, but, or no, but, you realize you're answering more than just question. Now again, if you're doing this on your own, you have to decide. Maybe you want to do that. Typically it comes up when you feel like the answer will make you not look good. So in a credit card type context, it might be, is it true that you took out this credit card, you made charges on it, and you refused to pay it? You're like, wow, that makes me sound kind of bad. And so, you go, yes, but let me explain. I had a job loss, or I went through this terrible divorce, or my position is you should only answer the question asked. At least if I'm representing you, I only want you answering the question asked. Don't start explaining it unless you're asked to explain it, because people get themselves into trouble doing this. Lawyers on the other side love it when you start trying to explain it and justify and answering more than the question. So again, you make your own decision if you represent yourself. But for my clients, we hammer this point home. Only answer the question that's been asked. What should I do if the judge asks me a question? You answer it. I've seen people say, well, Judge, I don't like that question. I'm not going to answer your question. That seems incredibly foolish to me. If the judge asks you a question, answer it. Here's my suggestion, the way I have my clients do it. You answer my questions, the other side's questions, questions from the judge. You answer those all the same. In other words, don't do a deal. I saw this one time in court where the consumer, when his lawyer would ask him questions, he would answer them perfectly. When the collection lawyer would ask questions, he'd go, what? I can't hear you. I'm confused by that. And he was just doing that on purpose. And, he kind of had this smirk on his face, and he's winking at his lawyer like, boy, I really showed that collection lawyer. What he couldn't see is the judge was about to just explode. You don't play games like that. You answer every question the same way. Answer it accurately, truthfully. That's your obligation. If you're asked a question, you are to answer that question truthfully, whether that's from your lawyer, from the other lawyer, or from the judge. That's my opinion on it. All right, will the debt collector always have a lawyer at trial? Yes. I suppose it's possible in small claims they might not have a lawyer, but I have never seen that. They're going to have a lawyer there. Sometimes people will say on the internet, collection lawyer won't show up. I have, with one exception, never seen a collection lawyer not show up. Collection lawyers will show up to trial. That's their job. And I can say, by and large, the collection lawyers in Alabama are very skilled. Now, there are some that I have some questions about, but the guys that I deal with on a daily basis, these are really skilled, talented lawyers, and they're going to show up to trial. So they will have their lawyer at trial. Now, kind of the other side of that is, will the debt collector send a witness to testify in trial? Usually not, but I can't promise you in your case because I don't know what your case is. So, if we represent you, we'll talk about that. If you represent yourself, you have to make your own judgment on this. Will they send a witness to testify at trial? I can tell you the normal answer is no. They will not send at least a live witness, a person in the flesh there who's going to testify. Well, what do I do if the collector has a witness? So they show up with a witness. Well, if you got a lawyer, your lawyer will cross-examine that witness. If it's you, you've got to figure out how to do that. And I'll just be blunt, that's going to be very hard, and that's way beyond the scope of this video. But if you represent yourself, you have to be prepared for they may bring a witness, and you've got to decide, how do I object? How do I cross-examine this witness? What's the difference in the purchase agreement and the bill of sale? Well, the bill of sale is something they typically bring to court. And this is where Midland or Portfolio or whoever it is will say, see, here's the proof that we bought the debt. And it's usually like a paragraph. It'll say on this date, Chase and Midland Funding purchased the accounts attached as Exhibit A to the purchase agreement for the terms of the purchase agreement. And they'll say, see, that proves it. But the purchase agreement is the actual document where they supposedly buy the debt. It's going to be a 30, 40, 50-page document. And it's going to explain who's promising to do what. So think of the purchase agreement as the contract. The bill of sale is just sort of the record of it saying, hey, there is a contract out there. And normally the purchase agreement is attached to the bill of sale. So does the bill of sale mean the collector has proven it owns a debt? They would tell you yes. They wave that thing around like this is the gospel truth. Look, we got the bill of sale. My position is, so what? You got a bill of sale. The bill of sale says, look at the purchase agreement that's attached to it. Where's the purchase agreement? They go, oh, that is top secret. That's like the formula to Coke or KFC's secret recipe. And they act like this is some just national security issue. It's not. It's a contract. It's like any other contract where you're buying stuff. So my view is the bill of sale does not prove anything because it's an incomplete document where we would really find some evidence about whether or not these accounts were purchased is going to be in that purchase agreement. And there's reasons that they do not want to share or put into evidence of purchase agreements, but just understand there's a big difference between the bill of sale and the purchase agreement. All right, well, what's an affidavit? Because a lot of times what we'll see is there's not a live person, not somebody there in the flesh, but they'll have an affidavit saying, we bought this and you can look at the bill of sale. So an affidavit is a sworn statement in writing, and it'll say something like, and usually it's got all these sort of fill in the blanks where they're just using a stamp on this stuff, like I, comma, and then it'll have the person's name stamped in there, and a lot of times it'll say like he, she, or something like that. It's kind of silly how they do it, but it'll say, we bought this debt and you, the consumer, owe it, and you have no defenses. And they go, see, Judge, this is my proof. So that's what an affidavit is. It's an attempt to get in testimony without bringing the person live and without giving you the chance to cross-examine the person. So does an affidavit prove the collector owns a debt? My position is absolutely not. Every affidavit I've seen, I've been representing just hundreds and hundreds of people over, 11 years now. Been a lawyer 22 years, but 11 years where I've been involved with these collection type suits. I've never seen an affidavit that I thought was valid. So I don't think it proves that they own the debt. They're always defective. So can the collector use an affidavit in your trial? Well, it depends on what court you're in. In circuit court or district court, as long as you object, no. The rules say they cannot use an affidavit because you're supposed to be able to cross-examine a witness, question them. In small claims court, it's up to the judge. What I have found from all my years of doing this is most judges will not allow these. When we're talking about these professional plaintiffs or serial litigants, as they're sometimes called, where Midland Funding will file 100 lawsuits a week in Alabama, and then they don't bring witnesses. They try to use affidavit. Really, the affidavit in small claims court is more for, like, two neighbors are fighting, and you get a third neighbor to testify, and we're not necessarily going to make him come down to court. But the judge has discretion on this, but most judges will not allow these affidavits. Or if they do, you can read the affidavit and point out the inconsistencies in it. All right, how about monthly statements? So they've got all the 5 months of old monthly statements from my credit card. Does this prove they own the debt? You know what it proves? It proves they have monthly statements. Now they'll wave them around like, look, we must own the debt because we have monthly statements. My response is, Judge, it proves they have monthly statements. That's all it proves. I mean, if I grab them out of their hands, now I got the monthly statements. I mean, I own the debt? No, of course not. There are so many copies of these monthly statements. It proves nothing. Okay? Now, they'll make arguments from it. You have to be prepared for that. But sometimes I've seen consumers representing themselves, and the lawyer goes, I got the monthly statements. I go, oh, well, I guess it's over now. And if you're representing yourself, just understand that it does not necessarily mean it's over. Now, you've got to make the right arguments, but having the monthly statements proves they have the monthly statements. That's all it proves. All right, so how does a debt collector prove it owns a debt? Well, let's think about it. How do we prove we own anything? Well, we might look for a contract where we bought it. We might look for a title. So if I'm proving to you I own my car, I go, here's the title to the car. Or if, imagine I'm getting into my car after shopping at Target, and some loss prevention guy comes out and says, hey, you stole that, loaf of bread. And I go, well, here's the receipt from 45 seconds ago, and it's got the loaf of bread on there. Oh, okay. So, we just kind of use common sense. Like, how do we prove we own a house, a car, a boat, anything? So how would the debt collector prove it owns a debt? Well, first, it's got to buy the debt. You can't own it if you don't buy it. Well, how do you prove you buy it? Well, there's a contract where you bought the debt. Well, what else would it be? Well, there'd be a description of the debt. So it's just kind of common sense things that in this world, the collection agencies, these debt buyers, they make it sound like, oh, well, we can't show you the contract. That's top secret. You should just believe us. Hey, we've got the statements. That proves everything. No. Prove you own the debt. This is a position I take. I've taken this for, I've lost track how many hundreds of trials we've done on these. So, again, if you're doing it on your own, you have to figure this out. But just think in general terms, like, how does somebody prove they own something? Well, that's what the debt buyer needs to do. And think about it this way, particularly if the debt buyer is like number 2 or 3 in line, well, we would need the previous debt buyer. So my position is, if they say Chase Bank sold it to Midland, who sold it to Portfolio Recovery, well, there better be a witness from Chase. There better be a witness from Midland, better be a witness from Portfolio. But again, you have to look at all that on your own. But just, again, think in terms of buying a car, buying a house. How would somebody prove that they have good title or good ownership of that debt? So what happens during the trial in small claims court? First of all, do I need to show up for my small claims trial? Yes, if you don't show up, you lose. Default judgment. It's over. How should I dress for trial? I used to tell people dress like you dress for church, but there are some very casual church services now, apparently. So here's the best way I can describe it. Dress in a way that shows respect for the court. So don't dress above the way that you would dress in a respectful way, but don't dress below that. Let me give you an example. I do not wear tuxedos. For me to wear a tuxedo, that would be dressing way too much for me. But if I'm going to a funeral, if I'm going to church, then typically I'm going to wear a suit and tie, at least a suit. If I walked into a funeral in blue jeans, that's not appropriate, in my opinion. So for me, and forget that I'm a lawyer, just saying if I was a party in a case, I would at least wear a suit and almost certainly a suit and tie. But for somebody that is, maybe they do labor type work outside, for them, sort of dressing up would be maybe a pair of khaki pants and a dress shirt. Well, it would be unusual for them to wear a suit, just like it'd be unusual for me to wear a tuxedo. Okay, so you kind of have to look at your own situation and say, I need to walk in this courtroom feeling comfortable. Like, I would not feel comfortable in a tuxedo. Some people would not feel comfortable in a suit. But you say, I want to feel comfortable and show respect for the court. So how would you dress if you were meeting the mayor or the governor or the president? You want to show respect for that judge and that court. So that's how I would dress. Should I get to trial early? Absolutely. You do not want to be walking in there at the last minute. Certainly not late. But if your trial's at 9, you don't want to come in and sort of completely out of breath at 9 o'clock. Judge calls your case and you can't even catch your breath. Get there early. Make sure you're in the right courtroom. Allow for traffic. get comfortable in the courtroom so that you're removing as much nervousness as you can. And so definitely get there early. Will my case be the only case going to trial that day? Very likely no. Almost every time I've been in small claims court, they may have 6 cases, a dozen. I was there one time where they had 100 cases set. That was really unusual. But very likely there's going to be multiple cases, and the judge will call those different cases. What happens when a judge comes in court? I would stand up. That's a sign of respect for the judge. Some judges like it. Some judges will, oh, no, keep your seat. But I'd still do it even if you think the judge is going to tell you to keep your seat. It's just a sign of respect. What are the rules of evidence? So rules of evidence mean, what are the rules that apply when I'm trying to get something into evidence, or the other side's trying to get something into evidence? The rules of evidence in small claims court are kind of relaxed. Okay, it's different than other courts. It's really up to the judge. The judge can make it very formal or can make it more informal. So that's one reason why I'm saying go watch your judge so you know. But the general rule is the rules of evidence are going to be much more casual and relaxed than if you were in district court or circuit court. Can affidavits be used? We talked about this previously. Maybe. A judge has the right to allow affidavits. A judge also has a right to not allow them. And in my experience, they do not allow them. And particularly if you start looking through there and you can point out all the errors in the affidavit, the judge is going to say, most likely, yeah, we're not considering this. All right, what about trial in district court? So do I need to show up for my district court trial? Yes. Same as small claims, same as circuit court. You've got to show up or you lose. Default judgment. How should I dress for trial? Same way as in any other court, dress respectfully. Okay, so you don't have to wear something that's unnatural for you. My example, a few slides ago was me wearing a tuxedo would be very uncomfortable, but I'm comfortable in a suit. For you, it may be wearing just a pair of nice casual clothes. That's the right level for you, and wearing a suit would make you very uncomfortable. Well, don't do something that you're going to be uncomfortable in. You're going to be somewhat nervous anyway, so just dress respectfully and appropriately. And certainly if you have a lawyer, we can tell you what we would suggest. Should I get there early to trial? Absolutely. You don't want to get caught in traffic, get caught in a line going through security, and now you can't get into the courtroom and you're late and you lose or the judge is mad at you. Get there early, be relaxed, be comfortable as much as possible. Will your case be the only case going to trial that day? Almost certainly there will be other cases. And so the judge will call the various cases, see who's here, who's settled, who needs to go to trial. So it's very unlikely that you would be the only person in the courtroom. All right, what happens when the judge comes in the courtroom? Again, I would stand. It's a sign of respect to the judge. What are the rules of evidence? In district court, we follow the Alabama rules of evidence. So these are the very formal rules about who can say what type of documents can come in. You might have heard of things called I object based on hearsay. Well, hearsay is a rule of evidence. Or somebody will go, that's immaterial or irrelevant. Those are rules of evidence. So the judges will follow those rules of evidence. So your lawyer will know about this, but if you're doing it on your own, you need to familiarize yourself with at least certain basic concepts of the rules of evidence so that you don't get blindsided by something from the collection lawyer. Can affidavits be used in district court? They can be, unless you object. And my strong suggestion is object to affidavits. You want the debt collector to have to bring somebody in person so that you can question them. They bring these affidavits. I mean, it's just absurd. We've seen over the past years, you have these robo-affidavits, robo-signed affidavits where, Joe Blow signs 1,000 affidavits an hour swearing under oath that he carefully reviewed everything. Well, that's not possible. We've even seen where the guy signed the affidavit, he died 6 months before. They're using a stamp of, fake signature. So I would object to affidavits. Certainly it's what I do when I'm in district court. So what about trial in circuit court? Well, again, some of these are very similar. Do I need to show up? Yes. Otherwise, you will lose your case. Should I get there early on the day of trial? Absolutely. Make sure you're in the right courtroom. Make sure you can kind of catch your breath, be comfortable, be as relaxed as possible. I mean, nothing like being stuck in traffic and there's a long line to get through security at the courthouse and you know you're running late. Think of it like an airport, okay? I'm not saying you have to get there 2 hours early, but you don't want to miss your flight. You do not want to miss your trial. How should I dress for trial? Again, dress respectfully and appropriately, showing honor to the court with how you dress. Don't dress in an unnatural way for you, but whatever would be appropriate for you that shows respect, that you can still feel comfortable in. That's how I would dress. Will your case be the only case going to trial that day? You know, in small claims in district court, it's pretty rare that there's only one case set. Occasionally we see that in circuit court. Normally, though, there are multiple cases set in circuit court. So there may be a room full of lawyers and parties, you know, the plaintiff, the one suing, or the defendant, the one who's been sued. So you might walk in, there's 10 people in the courtroom or 50 people in the courtroom. What happens when a judge comes in the courtroom? You stand up, you show respect to that judge. What are the rules of evidence? Really the same as in district court. We have these formal rules of evidence called the Alabama Rules of Evidence. These can get kind of complicated. And if you're doing this on your own and you're in circuit court, that is really a Herculean task you've set before yourself to understand the rules of evidence. We do have some resources that can help you kind of understand what are the critical rules to know. I mean, the best thing is to know all of them, but you really need to know at least a few of them to make sure the debt collector is not allowed to get in evidence that they should not be getting in. Can affidavits be used? I've certainly seen collection lawyers try and use affidavits in circuit court. You need to object. That's my opinion. It's what I do, is I object to them because I can't cross-examine a piece of paper. And the rule is affidavits should not be allowed. But again, if they offer them and you don't say anything, judge may allow it. All right, well, what happens after the trial in small claims or district court? How will I find out if I won or lost my case? Usually the judge will tell you right then. Sometimes the judge will say, you know what, I'll consider this, I'll issue a ruling, and you'll get it in the mail. But I would say 95% of the time, you're going to know when you leave that courtroom whether you were successful or unsuccessful, whether you won or lost your case. If I lose, can I appeal? Yes. You have to follow the deadlines. You have to look all this up on your own. Normally, the rule is 14 days is your time to appeal, but you've got to verify what that is, or your lawyer will do that for you. If I win, can the debt collector appeal? Yes. Whoever loses has the right to appeal, and you're appealing up to circuit court, the higher court, and then the case starts all over from that point. If I lose and I do not appeal, what does this mean? Well, it means the case is over. It means you lost and you owe that money. And you can't come back later and go, well, I changed my mind, or I want the judge to do something different. Once that time is gone, it is virtually impossible to get that judgment set aside. Well, what if I win and the debt collector does not appeal? What does that mean? Well, it means you won and it's final. It's over. And the debt collector can't come back later and go, well, you know, actually you do owe the debt. So I'll give you an example. This was years and years ago. Debt collector sues us, we win. We sue the debt collector in federal court, and we're talking to the judge about it, and the lawyer for the debt collector says, well, Judge, I mean, John's client really does owe the debt. Judge looks at me, I said, that's not what the small claims judge said. And the lawyer for the debt collector said, well, you know, it's a small claims judge. I mean, doesn't matter. Federal judge goes, oh yeah, I have to honor everything that small claims judge did. They ruled that the consumer does not owe the debt. That's final, and you will not say anything different in my court. So really important, if you win and the debt collector does not appeal, it's over now. All right, well, what about after a trial in circuit court? So how will I find out if I won or lost? I would say the majority of circuit court judges who try cases without a jury do not tell you right then who has won, who has lost. They typically will say, well, I'm going to think about this and I'll issue a ruling. And then you get that through the mail. What if I lose in circuit court? What are my options? Well, and again, I'm not going to cover every exception. Here are the basic options. You can appeal it, or you can ask the judge to reconsider it, what's called a motion to alter, amend, or vacate, if you have valid reasons for that. But the idea is you can ask either this judge or the appellate court down in Montgomery, Court of Civil Appeals, or the Alabama Supreme Court to rule that the judge made an error. Well, if I win, what does this mean for me? Well, it means that you do not owe that debt. And so that's a great ruling in your regard. Now, if you lose the previous slide, that means you do owe the debt. But if you win, you do not owe the debt. Well, if I lose and do not appeal, what does this mean? It means it's over. It's done. It is an established fact that you owe this debt. And it's incredibly hard to ever change that ruling. Well, if I win and the collector does not appeal, what does that mean for me? Same thing. It means you won, and that collector can't come back later and go, well, I want to put this on your credit report, or I want to sue you again, or I want to blow up your phone collecting this debt. No, there is no debt. You won. You do not owe the debt. Okay, well, now that I know all this information, what do I do now? Here's what, I'm just going to be very blunt with you. If you just learned this information, you do nothing, you just wasted your time. I mean, I'm glad you stuck with me and watched this incredibly long video, but it really does you no good if you don't take action. You have to have knowledge plus action if you want to have any results. Really, anything in your life. You need to know what to do and then actually do it. So you've got to take action. You've got to make a decision. Am I going to file bankruptcy? Am I going to handle this on my own? Hire a lawyer? What will I do? Let me make a decision now. Now, we're certainly happy to help you think through your options. Okay? You can call us 205-879-2447 or go to our website, alabamaconsumer.com. We'll help you think through those options. But let's say that you go, you know what? I want to hire a lawyer. How do I find the right one? Well, we talked about this a little bit earlier, but ultimately you need somebody that you feel confident in, that they know what they're doing, and you feel comfortable with them. Because this is a journey you're taking with a lawyer. You've got to make sure this is the right lawyer for you. And so my suggestion is if you don't feel confident in the lawyer, you're like, I don't know if this lawyer knows what he or she is doing. Well, why would you hire them? Or if you go, I think they know what they're doing, but I just do not feel comfortable. I don't trust this lawyer. Again, why would you hire that lawyer? Find somebody you feel confident in and that you're very comfortable with. So here's a very legitimate question. How do I know I'm not going to pay a lawyer and then get stuck with a judgment against me and have to pay even more money to the collector? I mean, that's something I would think about if I was in this position looking at hiring a lawyer. Here's kind of the solutions. One, if you pay the lawyer and then you lose, well, yeah, you're going to spend a lot of money. But I'll tell you the way that we sometimes do it, and every situation is different. Sometimes we'll tell our clients, look, I'm very confident we can get your case resolved, or if we try it, that we'll win. Now, I can't guarantee that, but if I'm wrong, then I give you your money back. Obviously, I can't guarantee what a judge will do, but I can say, if I'm wrong and I misevaluated this case, then I'll refund your money to you. And so that's one way to deal with this, but you certainly need to think about this question because you don't want to pay X number of dollars to a lawyer and then get hit with a judgment. Now you're paying more than the amount you were sued for. So talk to your lawyer about that. Obviously, if you're talking to us, we'll have this conversation, and that would be something that I think is very important to know the answer to. All right. Is knowing this information enough, or do I need to take action? Again, you've got to take action. It's like this. If I know how to drive from my house to Atlanta, and I sit in my car, and I am packed and ready to go, and I never turn the car, or I never step on the accelerator, how likely am I to get to Atlanta? Yeah, I'm not getting there. If I say, I need to lose weight, I need to get physically fit, and so I read all this information, and then I do nothing. Well, the information's worthless. I've got to know what to do and then take action. You've learned an incredible amount of information about debt collection lawsuits in Alabama. Now you need to take action. You've got to do something for this to have been worth anything at all for you. All right, well, where can I get a checklist or a worksheet to fill out as I decide what to do? I'm committed to taking action. I know that I need to learn this information and take action. I just need a little bit of guidance. Well, again, you can always call us. We'll do this over the phone. But I understand sometimes people want to do this on their own before they speak with us. And you certainly can go to collection suit checklist. So just think of this as a collection lawsuit against you, collectionsuitchecklist.com. There'll be a place there you can enter in your contact information, and you can download this little checklist or worksheet, and just will help you as you go through. Make sure you're keeping up with your dates. Hey, I was served on this day. I've got this long to answer. Here's how much it'll cost me to settle it. Here's how much if I hire a lawyer. Whatever the situation is, I think this little checklist is not very long. I think it's a page or two. It'll be very helpful to you. All right, congratulations. You've made it through quite possibly the world's longest video of all time. So I hope this was helpful to you. Remember to take action. We wish you only the best. We want you to be successful. If we can help you in any way, just pick up the phone, 205-879-2447. We'll have a very friendly, casual conversation. We're not judging you in this conversation. We just want to talk to you, help you evaluate your options, and then help you discover for yourself, not for anybody else, but for you, what is the best option. And then we'll encourage you to take that action. So again, thanks for being with us. You can reach us at 205-879-2447 or alabamaconsumer.com. And appreciate you watching this video, and I look forward to talking to you soon. Bye-bye.